Good morning, professor and classmate. My name is Lê Thu Hà, and today I will present topic 9, the legal status of archipelagic waters and its international practice. My presentation will be divided into 3 parts. Part 1 is introduction, Part 2 is legal status of archipelagic waters, and the last part is international practice. In Part 1, introduction, I want to talk about the way that I structure my presentation. In terms of legal status of archipelagic waters, I will talk about the rights and duties of archipelagic country as well as other country and their vessel, their ship. And in terms of international practice, we will answer the question how archipelagic countries applies the legal status in archipelagic waters. So let's move to part 2, the legal status of archipelagic waters. The first point that I hope all of you will remember is if a country has archipelagic water, so that country also has sovereignty over that waters, which is mentioned in Article 2.1 and 49.1 of the Law of the Sea Convention. And the second point that I hope you remember is the sovereignty of a state over its archipelagic water extends to the aspect above archipelagic waters as well as to the seabed and subsoils and to its resources, which is mentioned in Article 2.2 and 49.2 of Law of the Sea Convention. So, through Article 2 and 49, we have a basic understanding that once country have the archipelagic waters, so that country also have the sovereignty over that water and the airspace above the waters and everything under that water, including the bed, subsoil, and the resources. But the question here is what types of sovereignty here? I have to say that I have no idea about this subject, and when talking about sovereignty, I just thinking about the sovereignty over the land, like a country have the supreme power in executive, in legislative, in judicial. No one or no country have the right to intervene to their activities, but it is the same with the sovereignty over the land and the sovereignty over the archipelagic waters. And so answer is in no. The complete and absolute sovereignty over the sea is sovereignty over the internal waters. It is understood simply as all the rules and regulations applied on land are the same with internal water. But archipelagic water is not totally internal water, so the sovereignty of a country over its archipelagic waters have some limitations. And in my opinion, this limitation can be seen as the right for foreign country and the duties for the archipelagic state. So talking about the sovereignty of archipelagic state over archipelagic waters, I will divide it into three categories: the fishing, the capable, submarine cables, and the traffic. So the first one is fishing, which is mentioned in Article 51.1. So because the archipelagic state, they have sovereignty, so of course they can fish in this water, but at the same time they have to respect existing agreement with other states and recognize the traditional fishing rights and other legitimate activities of adjacent neighboring states. So it means that foreign states also can catch fish in archipelagic water if they have the multilateral or bilateral agreement with the archipelagic state, or in the past they used to catch in this area like a traditional area, so they still can keep fishing there. So the next point is the submarine cables. You can read more detail in Article 51.2. So archipelagic state respect existing submarines capable led by other states and passing through without making a landfall. Archipelagic states also permit the maintenance and replacement of such cables upon receiving due notice of location and intention to replace or repair. So it means that foreign states can keep their submarine cables and continue to replace and repair before giving notice to archipelagic state. And the last point, as well the most important point, is the traffic. So here, the foreign state can travel through the archipelagic waters based on innocent passage principle and archipelagic traffic principle. Innocent passage principles is one of the oldest principle talking about the freedom of the sea, and I think you have the basic understanding about this, and you also can read more in section 3 of Law of the Sea Convention. But based on the innocent passage principle, the archipelagic state can suspend temporarily in specified areas of its archipelagic waters if such suspension is essential for the protection of its security under Article 25 relating to innocent passage. Beside the innocent passage principle, one of the oldest principle, we also have a new principle which named is archipelagic traffic principle. Under the types of traffic, archipelagic state can establish sea lane to ensure the passage of foreign vessels. But in case they doesn't create sea lane, they have to respect the commonly used navigational rules used in international maritime traffic. And talking about archipelagic passes, there are some rules that the archipelagic state have to follow, which is mentioned in Article 53 of Law of the Sea Convention. There are 3 points that I hope you remember. The first point is the sea lane and arrows must travel the archipelagic waters and the adjacent territorial sea and shall include all normal passage rules used as sea rules for international navigation are overflowed through over archipelagic waters. The second point is the sea lane and arrows shall be defined by a series of continuous exercise lines from the entry points of passage rules to the exit point. So this is the way how a country creates the sea lane. And the last point is the designation of the sea lane and arrows and any associated ship routing measures must conform to general accepted international regulations and is subject to adoption by international maritime organizations. So it means that they cannot create the sea lane or the arrows by themselves. They have to submit and ask for the approval of the International Maritime Organization. But I have a question that why we need 2 types of traffic here, the innocent passage and the archipelagic water traffic. And the question, the answer is the archipelagic passage is created to balance the principle of international freedom of navigation and the state sovereignty. In the past, many states said that the innocent passage in archipelagic water is not free enough. They still limit their right in the sea, and this is the reason why archipelagic passage was born, and it's the more freedom than the innocent passage in some point that you can read in my report. But I can mention some points innocent passage just include the maritime traffic, but the archipelagic passage includes both maritime traffic, in the sea, and the airplane, the arrows. Yeah, so this means that it's the more freedom, right? And the second point, talking about the nuclear ship or ship bring the hazardous material, something like that. But there is also one difference between the archipelagic passage and innocent passage that you should remember is innocent passage. They just travel in this place, and the country doesn't have to ask for any organization to create anything, but here archipelagic passes, they have to ask for the international organization if they want to create the sea lane and air rules. So this is part 2, legal status. Now I will move to part 3, the international practice. In this part, I will divide it into 3 small parts, talking about the apply of all state relating to this article. So the first article is Article 49, the legal status of archipelagic waters. So up to now, 20 states have utilized archipelagic provisions by enacting baseline, within which these states claim sovereignty water subject to navigational rights of other states. And within 20 countries above, 19 countries have properly articulated the legal character of the water within their vessel archipelagic baseline. They enact law, and you can find in Google a summary of UN about this law. But there is one tricky case of the Philippines. In 2009, the Philippines enacted legislation establishing its archipelagic baseline. However, this legislation didn't clarify whether the water within the baseline are archipelagic waters. They said that the concept of archipelagic waters is similar to the concept of internal waters under the Constitution of the Philippines, but this way go contrary to the Law of the Sea Convention. So many countries have object this idea and the draft of the Philippines. The next point is Article 50, delimitation of internal waters. As provided in Article 50, within its archipelagic waters, the archipelagic state may draw closing lines for the delimitation of internal waters in accordance with Article 9, 10, and 11. And there are 6 of the 20 states examine this right. They have delimited internal water within their archipelagic waters. But there is one case of Papua New Guinea as well as many other countries that they also have the legislation that authorize or describe the rules for the delimitation of internal waters, but they not go exactly the way as the Law of the Sea Convention describe to how to delimitation the internal water as Article 16. So the last point is the Article 52 and 53 talking about the navigation. And up to now, only Indonesia has designated archipelagic sea lanes and air routes under the acceptance of International Maritime Organization. They created 3 sea lanes and air routes, but although they create sea lanes, they also accept and recognize and respect the traditional rules. And because only Indonesia had designated the sea lane, the predominant worldwide practice is for foreign ships to have the right to exercise archipelagic sea lane spaces through the rules normally used for international navigation. One more thing, 12 archipelagic states recognize the rights of archipelagic sea lane passes in their laws, although not always using the precise terminology in Article 53. But there is a case of Maldives. The Maldives legislation that just partially recognizes this right, in that it includes ship but not aircraft. But as you know, archipelagic passes includes both ship and aircraft, but here Maldives just recognize ship, not aircraft. And there is also one case of Dominican Republic. The recognition of the rights of archipelagic sea lane passes is unclear. The unclear here is in their law, they're just talking about the innocent passes, not archipelagic sea land passes, but they cover both fly rights and ship right. But you know, the innocent passage doesn't include the flight. They just have the ship. Yeah, so this is something we call unclear. Besides, many countries had mentioned about the archipelagic traffic. We also have 6 archipelagic states appear to contain no mention of the rise of archipelagic sea lane passes. However, even they didn't have this types of recognition in their law, we still the absence of express legislative recognition should not necessarily be construed as non-recognition of the rights. We still considering that this state respect the passage right in practice even without legislative enactment. But beside this case, like they haven't enact law, but they like in some way they still conform with the Law of the Sea Convention in terms of archipelagic passes. But there are some restrictions on the passage of ship and aircraft through archipelagic waters. For example, the laws of Antigua and Barbuda, Maldives, Seychelles, Saint Vincent and the Grenadines, and Vanuatu require that foreign warships receive permission from their respective government prior to navigating in their territorial sea or the archipelagic waters, while Law of the Sea Convention doesn't mention about it. So, this is on the international practice, and here is my conclusion. So as you see, the legal status of archipelagic waters have many similarities with inland water, but the sovereignty over archipelagic waters is not absolute, but depends on multilateral agreement and international law. And about the international practice, the application of archipelagic legal status is varied. Archipelagic states do not object but not apply exactly the same as Law of the Sea Convention. So thank you for listening.